Today, I will talk you through the offense of handling stolen goods in the UK, Nigeria, and other Commonwealth countries. A serious criminal offense in the UK under Section 22 of the Theft Act 1968 and Nigeria Section 427 receiving stolen property of the Criminal Code, which applies in Southern Nigeria, and Section 317 to 322 receiving stolen property of the Penal Code applicable in northern Nigeria. And I will also consider how it is treated in other Commonwealth countries. This offense targets people who assist thieves after the crime, either by receiving, disposing, or helping to sell stolen property. Understanding this offense is crucial because it sits at the intersection of theft, conspiracy, and money laundering. Definition and rationale. What is the offense of handling stolen goods? Handling stolen goods occurs when a person dishonestly handles property known or believed to be stolen other than during the act of the theft itself. A fence is the legal term used to describe a person who buys, receives, or sells stolen goods, knows or has reason to believe that the goods are stolen, acts as an intermediary between thieves and the final market, helping thieves convert stolen property into cash or other goods. The fence does not steal but profits from the stolen property. Example, in the UK, a fence purchases a stolen laptop from a friend knowing it was taken from a shop without permission. Example, in Nigeria, in Lagos, someone buys second-hand phones at a fraction of their real price from a known fraudster. Question 2. Rationale behind the offense. The law aims to disrupt the market for stolen goods and deter people from supporting criminals after the theft. By criminalizing this behavior, it discourages receiving, storing, selling, or arranging for disposal of stolen property. In Commonwealth countries such as Australia, a group sells stolen electronics online. Even those who merely facilitate shipping are liable. What counts as stolen goods? Goods are stolen if obtained through theft, robbery, burglary, blackmail, fraud, or previous handling. See the case in the UK, Regina against Locke, 1970. This confirmed that only post-theft handling counts. The thief cannot be the handler of the same goods. The Actus Reus, or the guilty act. What constitutes the Actus Reus? It includes receiving stolen goods, arranging to receive them, assisting in retention, removal, disposal or realization, arranging on any of these acts for someone else. Key point: physical contact is not required. Constructive handling, such as arranging sale or storage, is sufficient. See the case of Rationale against Commonwealth 2004, where holding goods on behalf of another counted as handling. In Nigeria, someone stores stolen generator sets for a friend, knowing they were stolen. In Toronto, Canada, a student agrees to sell stolen concert tickets online, even though they never touched the tickets. Arranging the sale qualifies as handling. When is the offense complete? The offense is complete once the defendant deals with the goods in a prohibited way after theft is complete. For example, UK, a fence buys stolen bicycles and resells them. Each resale counts as handling. What is the mens rea or the guilty mind in handling stolen goods? Prosecution must prove A, dishonesty, and B, knowledge or belief that goods are stolen. What is the level of knowledge required? The defendant must know or strongly suspect that goods are stolen. Mere suspicion is insufficient. See the case of Rationale against Hall, 1985, in which the court clarified that knowledge of theft is essential. What does belief mean? Belief implies accepting the risk that goods may be stolen. See the case of Rationale against Ghosh, 1982, in the UK. Historically, dishonesty was assessed by the Ghosh test, now replaced by Ivy and Genting Casinos case 2017. What did the defendant believe the facts to be? Would ordinary decent people consider it dishonest? See the case in Nigeria: buying second-hand electronics at far below market price from a known thief may be evidence of belief that goods are stolen. In Commonwealth countries such as Australia, accepting a too good to be true deal on high-end phones from an unknown seller while suspecting they are stolen. Part D, key limitations and defenses. Timing of handling. Handling must occur after theft is complete. Involvement before or during theft makes the person an accessory to the theft. See the case in the UK of Rationale against Dolan, 1989, in which handling goods recovered by police counts if the defendant believed they were stolen. Defenses include lack of knowledge or belief, absence of dishonesty. Goods are no longer stolen when returned to the owner. Acting under duress. honest intention to return goods to owner or authorities. For example, in Nigeria, a person finds stolen jewelry and immediately returns it to the EFCC. Defense applies. UK, a courier unknowingly delivers a stolen package. Lack of knowledge may absorb liability. Punishment. What is the punishment in the UK? In the UK, it carries a maximum sentence of 14 years imprisonment. And tried either way, magistrate or crown court in the UK. In Nigeria, similar penalties under Criminal Code sections 319 to 321. Example, EFCC prosecuted a Lagos fence of stolen vehicles with 5 years imprisonment imposed. Commonwealth example, in Australia, penalties vary but can attract up to 10 years imprisonment depending on value and circumstances. Comparison with theft. Key differences. Theft involves taking property. Handling stolen goods involves dealing with property after theft. The thief cannot handle their own stolen goods. The handler cannot be the original thief or post-theft. Example, in Nigeria, a thief steals a generator. Someone buys it from him. The buyer is guilty of handling, not the theft. Example, in the UK, shoplifter steals goods. The person who sells them is guilty of handling and not theft. Real life examples. In Lagos, Nigeria, in an electronics market, buyers knowingly purchase stolen phones. EFCC will prosecute. In the UK, Birmingham, stolen bicycles sold online, handler convicted under Theft Act 1968, Section 22. In Commonwealth countries such as Australia, Sydney, ring of stolen electronics, handlers received custodial sentences even if they never touched the goods physically. And in Toronto, Canada, online resale of stolen concert tickets, arranging the sale without possession, sealed guilty. A person receives a package for a friend, suspects it's stolen and delays reporting. The suspect is liable for handling stolen goods. For those of you who are doing exams, here are some tips. Determine timing before or during theft. Consider theft or complicity. After theft, it is handling. Analyze mens rea, dishonesty plus knowledge or belief. Identify defenses, knowledge, duress, and intention to return. Always distinguish theft versus handling. Remember in exams, clarity on the timing of the act, mental state, and evidence of knowledge or belief is key to applying the law correctly. In summary, handling stolen goods criminalizes post-theft dealings to prevent the circulation of stolen property. It applies across Nigeria, the UK, and other Commonwealth countries with minor statutory variations. Key elements: Actus Reus handling, mens rea, dishonesty plus knowledge, timing and offences. Understanding real life examples from Nigeria, the UK, Australia, and Canada helps appreciate how the offence operates in practice. Comment and let's share your views in the next. Thank you.